rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the Court is now sitting. God save the state of Texas, this Honorable Court.
Please be seated. We'll hear argument in 3 cases this morning. First is 19-872, Memorial Hermann Health System against Gomez from Harris County and the First Court of Appeals District. Justice Bland is not participating in that case. Then next is 2639, Nettye Engler Energy versus Bluestone Natural Resources from Tarrant County and the Second Court of Appeals District. And finally, 2725, Dohlen versus the City of San Antonio from Bexar County and the Fourth Court of Appeals District. The court has allotted 20 minutes per side in each case and will take a brief recess between the arguments. The arguments are being webcast live this morning and will be available in the archives later on our website. Justice Lehrman cannot be present this morning, but expects to participate in the decisions of all 3 cases. We're ready for argument in 19-872, Memorial Hermann versus Gomez.
May it please the court, Ms. Pfeiffer will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. The $6 million judgment before the court awards identical damages to a doctor for defamation and to his physician association entity for business disparagement. Yet there is no evidence of a viable defamatory statement, there's no evidence of causation, and there's no evidence of an injury. There's a lot in this case that we could talk about today, but I'd like to try to touch on those 3 points. First, that the quoted statements in the jury charge are the only ones that can be properly reviewed, and they both lead to a very easy path to rendition. Second, that the expert's causation opinion is conclusory, and there is a glaring failure to exclude plausible alternative causes. And third, that the lost profits model is likewise conclusory, and there is no separate evidence of any reputational harm. So first, starting with the quoted statements, we've put those in the bench exhibits at tabs B and C, so the court has them handy. Defamation cases have to be pleaded with particularity. They have to be proved with specifics. It's kind of like a fraud case. You need to know who, what, when, to whom. There's all sorts of details that you need to be able to try and prove a defamation case. And where a plaintiff identifies a statement and submits a quoted statement in the jury charge, the courts must review the statement as quoted. That is our basic position. If the court agrees with that, both of these statements fail because, as quoted, they cannot support a defamation claim. The Todd statement at tab B was not repeated to anybody that would connect to the damages model. The whole premise of this case is that there was a decline in CV's surgical volume that was caused by a loss of referrals, and so the plaintiffs needed to show that some defamation actually reached a referring physician. And this statement at tab B, what we call the Todd statement, was made by an employee of Memorial Hermann to an employee of Methodist West who repeated it to the CEO during the hiring process, and they decided to hire Dr. Gomez, and that's where that ended. So it does not connect to any of the damages that have been alleged in this case. The second statement, what the plaintiffs call the Aussie Statement, is a statement from Brian Aussie, a Memorial Hermann employee, to Dr. Gomez, and was not repeated to any other person. This quoted statement was solely repeated to the plaintiff, which fails on the element of publication to third parties. So the plaintiffs in the Court of Appeals tried to reimagine and reinterpret these statements, and that's how the appellate court affirmed the judgment, is that they reimagined these statements as something far more amorphous to represent either circulating rumors or use of data. And those concepts cannot be reviewed by an appellate court because you can't test it against all the elements of defamation.
Wasn't the jury confused about the Aussie Statement as reflected by the question that they asked the trial court?
Yes, I think they were. And they saw the issue that if it's only repeated to Dr. Gomez, it doesn't go anywhere.
And so why weren't they given more information in response to that question? Why wasn't the jury given additional information at that point?
Well, there was a debate on the record with Judge Moore about what the jury should be instructed. And we said, Judge, it's the quoted statement. And he said, well, if I instruct them that, I'm directing a verdict. And we said, right. I mean, the quoted statement does not support defamation, but he could not reinterpret the statement.
There are two statements in the quote. There's the statement that he's making, and then the statement that he's shown it to cardiologists at cardiology meetings so they can make informed decisions. So what do we do with that? Well,
there's nothing that can be done with that because the plaintiffs didn't have anything more specific underlying this quoted statement. And Justice Busby, if you look at tab B in the bench exhibits, behind the quoted Aussie statement, there's a slide that shows all the unanswered questions that if we're trying to unpack this statement as somehow the statement within the statement, we don't know anything about it. We don't know what was shown, what data we're talking about. We don't know when. We don't know to whom it's shown. We don't know from this statement whether Aussie was saying that he was showing it inside a privileged meeting or outside of these meetings. And that's actually really important.
Did you object to the jury charge on that ground?
No, because there's nothing objectionable about the form of the jury charge.
Why? If you read it to be talking about the statement within the statement.
Well, because as a quoted statement, that is the statement that's being asked for findings. And so to be clear, we had been objecting since before trial that you can't have some vague amorphous concept submitted to the jury. That's at tab D of the bench exhibits, and you can see since pre-trial, we'd been standing up in court saying we need to know what the defamatory statements are, and the judge agreed. He said they'd have to be specifically listed in the jury charge, and at tab D it shows the limine rulings where the judge agreed and granted our limine point before trial that only evidence that is tied to specifics could be admissible for defamation or could be argued to be defamatory. So it had to identify a speaker and what they're saying and when it happened and to whom. We needed all of these specifics because in a case with a hospital, there's lots of people within a hospital that are not Memorial Hermann employees. And so the plaintiffs needed to be able to attribute it to somebody who was a Memorial Hermann agent or employee, and we needed to know specifically what we're talking about and when.
Is there a case that says if those specifics are not in the jury charge itself, but are supported by the evidence, that's not enough?
I don't know that there's a case specific to the jury charge
Right.
issue, but there's certainly cases, lots of cases, that talk about you need the specifics in the evidence. So they don't have the specifics in the evidence. That's the whole point. The reason they don't have a more specific statement for the jury charge is because they don't have the evidence to have quoted it. And at tabs E and F, this is a very important point that I don't think the Court of Appeals fully appreciated. All the data in this record was shared in statutorily privileged meetings. That was the whole mandamus proceeding that went up to this court in this case several years ago, where the court held that this privileged material was discoverable in this case because of the anti-competitive action. There's an exception where you can get privileged materials for antitrust claims. So they had privileged materials in this trial, but that could not be used to support defamation or business disparagement without getting separate findings to overcome the statutory immunities. So the plaintiffs were trying to find something that happened outside of a privileged context. They quote this statement by Brian Aussie to Dr. Gomez out in the hall because that's not a privileged meeting, and that is the statement the jury made findings about. Turning to causation. Regardless of how the court views the charge, There is no evidence of causation, and we've put a lot of the testimony into the bench exhibits so the court has handy the specific testimony that we're looking at tabs, the last 4 tabs of the bench exhibits. This case fails for all sorts of reasons. Part of it is the equal inference rule, that the premise of the case from the plaintiff's perspective is that these people within the hospital had to know that Dr. Gomez had high mortalities because data was being shared outside of a privileged context. That doesn't work because mortalities are common knowledge within a hospital. And so there were lots of ways that people would find out that there are deaths. And the evidence, if you look at the timing of it, and the timeline at tab A is actually really, I think, helpful in showing that people had concerns about this CV surgical program having high mortalities before the data initiative. It was early 2009 when this Todd call allegedly happened to Pena, when she was saying there's concerns here. It was early 2009 when Brian Aussie was hired, and his first priority when he was hired was to look at the cardiologist's concerns that there had been high mortalities in the CV surgical program. And so that is why they started looking at this. They set all the doctors' cases out for peer review. Then they started this data initiative to start looking at the mortalities and the rates and seeing what could they do to improve the mortalities. So there is no reason to infer that anybody would have come to an opinion that Dr. Gomez had high mortalities based on anything about the data when they could have learned this simply from being in the hospital knowing that their patients were dying. This case makes it very much like the Hancock versus Varian case, this court's doctor defamation case from a few years ago, where there are multiple inferences that can be drawn, none more plausible than the other, and so you can't draw the inference that the plaintiffs are asking to be drawn. Same with Marshall Field Store's case. It's a case about rumors within a store that couldn't be attributed to defamation because it had been common knowledge. And so when rumors arise because of common knowledge, you cannot infer that defamation caused that knowledge. I also want to touch on the plausible alternative causes. This court discusses this issue a lot. I mean, the Houston Unlimited case is a great example. This comes up a lot in this court's jurisprudence. And it's such a glaring error in this record that I think it's a very easy issue for the court to deal with. The premise of Dr. Gomez's case, again, is that because his CV surgical volume was declining over time, starting in 2005, 4 years before the alleged defamation, because it was declining over time, he wanted the jury to infer that that had to be because of defamation, reaching his referring doctors and causing a loss of referrals. And Memorial Hermann introduced evidence of 3 different explanations for why CV surgical volume would decline over time. One, because of medical advances, where less invasive techniques like stents and balloons were being used instead of the high-risk CV surgeries. That was a known national trend that was undisputed in this record. Another is that when Dr. Gomez resigned his privileges at Memorial Hermann and went to Methodist and limited his practice solely to one hospital, that causes a decline because all the doctors agree that they typically would refer patients to surgeons within their own campus. They try to keep it in-house. And so when you resign privileges at one hospital and move hospitals, you're going to lose the established referral base that you had from your prior hospital. And finally, he had a vein practice. And so in 2005, his CV surgical practice started declining, again, before the defamation, because he was devoting time to this side business. And then he wanted to say, well, after the defamation in 2009, it continued to decline, but he didn't want to account for the Vein Institute where he worked from noon to 6 every day. So he has this thriving side business that was growing over this same span of years. It was growing into $1 million business, and his experts did not account for that at all, that his afternoons were completely consumed with a side practice. So as the defendant, our job is just to introduce evidence of plausible alternative reasons why his CV surgical volume would be declining over time. The plaintiffs then have the burden to exclude that. And the experts just gave this the back of the hand. They can't just give it the back of the hand. They have to actually reason through this and explain why that would or would not impact their analysis, and they just didn't. So the damages expert testified not $1 was deducted for any of these alternative reasons why the CV surgical volume would be on a declining trend.
For a legal sufficiency review, do they have to exclude the alternative reasons if there were legally sufficient evidence that the defamation was the cause? So, for example, if he had brought several referring doctors who testified, I quit referring to him because I was told this bad information about him, and that was on the record, no dispute about that, then he wouldn't also have to negate the alternative reasons, or your position is he would still have to negate the alternative reasons for purposes of a legal sufficiency review?
You still would have to address the alternative reasons and exclude them with reasonable certainty. And your question raises a good point. To be clear about this record, there was no cardiologist who ever said, I've stopped my referring to Dr. Gomez, or that this had any effect. Nobody had ever heard any defamation with any specificity. There was only testimony from a couple of people who said they'd heard rumors, but nobody said they changed their referral patterns. They all said we'd still refer to him. But even if he did have that testimony, I do think this court's jurisprudence says you would still have to address plausible alternative causes because they could have some impact, right? So even if they aren't the sole cause, they could have some impact that you would have to account for in coming up with the damage model. And finally, turning briefly to the damage model, the easiest, cleanest point here is that the expert admits she has to use a discount rate, and she uses a risk-free discount rate of 2%. That's the U.S. Treasury bond discount rate. That is totally conclusory when you're talking about a physician's solo practice. And it makes this case very much like the Southwestern Energy versus Barry Helfand case, where there was just a flawed input without any basis that infected the entire damage model and made it no evidence.
Does that also affect the 205 procedures damage model?
Yes. And to be clear, because I saw that there was an argument in the briefing that we hadn't challenged that, we did challenge all the damage models with a Daubert motion. That goes to the cherry picking point. That's the reliability challenge. But this point about the discount rate is a legal sufficiency challenge about the conclusory input that is multiplied. The discount rate is multiplied by the entire model. And we challenged that with the JNOV.
Any other questions? Thank you, Ms. Pfeiffer.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Lee will present argument for the respondents.
Excuse me. May it please the court. This case is about the clash of two separate kinds of interests. Memorial Hermann's administration had an interest in retaining Dr. Gomez's patient base when it learned that Dr. Gomez was going to expand his practice to Methodist West. On the other hand, Dr. Gomez had an interest in delivering patient care to his patients and was doing that when he was the victim of a patterned campaign of defamation. The thing that the court needs to keep in mind is that we are talking about an administrative action by Memorial Hermann to create a metric that measures surgical quality, and every expert that testified, including Memorial Hermann's experts, testified that the metric was invalid and inaccurate. It didn't show the quality of care. It statistically didn't work. The metric is the individual surgeon's mortality index. And when you hear or read statements about how Dr. Gomez had high rates of mortality, that's what it is based upon, is a statistical analysis of mortality data that Memorial Hermann itself created, but it's an inaccurate analysis, and Memorial Hermann ultimately knows that. The reason that we know that Memorial Hermann knows that that measure is inaccurate is that the first cycle of information in this case, which runs from 2009 to early 2010, culminates with a doctor whose name is Rick No, it's NGO. Dr. No is the head of the peer review process that analysis of the cardiovascular surgeons would be subjected to. Dr. No is brought in by the Memorial Hermann administration, specifically by Keith Alexander, who's the CEO, and by Brian Auzine, who's the gentleman who actually creates this metric, to review information that Memorial Hermann has gathered on all of the cardiovascular surgeons.
And when you say that information was inaccurate, you don't mean that they miscounted?
No.
So the data was what it was.
The raw data is what it is.
And this is a pretty savvy crowd. So why didn't they realize, well, sure, that's what that says, but that doesn't have anything to do with this over here?
If we're talking about the administration, Mr. Alexander and Auzine, it's Dr. Gomez's position is that they intentionally use the metric in order to make Dr. Gomez look worse, in order to cut down on his referrals, and thereby eliminate the possibility that he takes patients from Memorial Hermann to Methodist West. Let's talk, though, for a moment about what's wrong with the data, because it's not as easy as it seems. It is true everybody knows what the wrong numbers are. This particular metric is based upon a different sort of calculation that's done by the Society of Thoracic Surgeons. That STS is how you will see that referred to in the briefs and in the record. The STS measures mortalities that are caused by not surgical misadventures, just bad results from surgeries. But the STS measure doesn't do it on a doctor-by-doctor basis. It does it on a facility-by-facility basis, and it's
To that point, I understand that all of the data that were circulated, so even giving the questions in the charge the broadest reading possible, as the Court of Appeals seemed to have done, how can they be defamatory if they don't identify Gomez by name?
First, Gomez was identified by name in several specific instances. Dr. Gibson, who's the chief medical officer and also was Dr. Gomez's partner, comes to Dr. Gomez in late 2009 and tells Dr. Gomez, I hear that Memorial Hermann has information on you that you're a bad surgeon. Excess mortalities, you are going to be proctored or suspended. And for a cardiovascular surgeon to have either one of those things happen to him, that's the kiss of death to your career if you're a surgeon who's gotten proctored or suspended. So Gibson knew who it was. He'd heard from somebody that Dr. Gomez had a quality of care problem. Additionally, that the testimony from Dr. Berman, and this is sequentially later in the entire proceeding, in the entire timeline, I'm sorry, not in the proceeding. Dr. Berman, who's a cardiologist, testified that Dr. Berman, knew Dr. Gomez, so Dr. Berman didn't reduce his referrals because of what has been labeled the whisper campaign. But Dr. Berman testified that other cardiologists did. They heard that Dr. Gomez basically was a bad surgeon and had altered their referral patterns. And
So do you mean that there is evidence in the record that the recipients of these spreadsheets with the data, being insiders, would have been able to decipher that which of these worst mortality rates related to Gomez?
Yes, we're talking about 4 cardiovascular surgeons, so it's a small universe to begin with. When this court heard the mandamus, Justice Willis, speaking for the court, wrote that the mere fact that the information is de-identified doesn't mean that witnesses or jurors aren't going to be able to figure out who are the problem surgeons. In the final meeting, there's a second cycle of this entire progression. Dr. Gomez is specifically, impliedly identified by Dr. Macris in a meeting in which there are a large number of doctors, both surgeons and cardiologists, and Dr. Macris, upon hearing Dr. Gomez's complaints that you're using the bad data again, Dr. Macris says something to the effect of, well, the only people that have to worry about that are the ones that are red flag surgeons. And Dr. Gomez's testimony is that it was clear that communicated to everybody in that particular meeting who was being talked about. But there is other evidence in the record in addition to that specific instance. And I think it's the other evidence that really is more probative. When you have Berman talking about it's generally known, it's in the air, the referring doctors have heard it and they're reacting to it because they're different than me, speaking as Dr. Berman, because they don't know Dr. Gomez. And it's a relatively small community, small number of people involved, and there's just lots of information that's leaking out about Dr. Gomez. Let's get back to the mortality index itself, because the Chief Justice says, okay, these are smart people, why didn't they realize what's going on? There's really 2 answers to that. One is they're smart people, but statistically they're not especially sophisticated. Brian Auzine, who's the one who created the metric, his background, to the extent that it's related at all, has studied radiology. He's got a business degree. He is by admission not a data analyst person and not a statistician. The problem with the measure that they created is, first, the sample size is much too small for it to be meaningful. With the STS data, you're looking at larger numbers of doctors because you're looking at facilities and comparing other facilities. When you look at individual doctors and try to correlate their individual mortalities, you never end up with a big enough big enough number of subjects to be able to generalize from. Anything you can say based on that sample isn't statistically significant. It's not showing a relationship. And this is not something that is necessarily going to be clear to people that don't have the background. But it is clear to people like Baron Hammond, who was the quality expert that Memorial Hermann hired, and it's clear to Rachel Dohlen, who was a witness called by Dr. Gomez, who ran the STS program that did the STS measure. And they both said, statistically, this doesn't do you any good at all. It is simply not a valid measure because the sample size is too small. It's also not a valid measure because when Memorial Hermann did it, they aggregate different kinds of procedures in order to get enough deaths to talk about. But if you're aggregating different kinds of procedures, you are not doing the same thing that the SDS does, which is looking at specific kinds of surgeries and comparing the specific kinds of surgeries. Why is that important? That's important because if you're just looking at a given kind of surgery, and you've got a large enough subject group, you can risk adjust the data. If you aren't looking at one type of operation and a large enough basis, you can't risk adjust the data. And the fact is, and everybody knows this, but statistically it becomes important when you start mixing apples and oranges. The mortality rate that you have for any given surgery is going to depend an awful lot on the health of the person who's being operated on. And you can tell that if you use the STS data, and you can adjust it so that the fact that one group of surgeons are treating people who are more, have greater morbidity than normal, then they're going to get worse results. But it doesn't mean anything in terms of their effectiveness as surgeons. They're just working on people who are older, or people who are smokers, or what have you. Some don't get through the surgeries as well as others, and you can adjust for that as long as you don't aggregate all the data. Memorial Hermann aggregates all the data, and so admittedly, although they say that the data is risk adjusted, when asked, they say, well, no, actually it's not. We can't risk adjust it because of the way that we do it. The third thing that's a problem with this particular metric is it doesn't measure quality of care. That's not what it was intended to do when the STS set it up. It's intended to show large tendencies within institutions. But when Memorial Hermann uses it, the intent is to separate good surgeons from bad surgeons, and this just won't do it at all. All right, that was a lot on statistics, and I apologize to the court for I sort of like statistics personally. For that digression, what's important about that is that in early 2010, we've got Memorial Hermann reporting that we've got 4 cardiovascular surgeons, 2 of whom appear to be the primary drivers of excess mortalities in the cardiovascular surgery unit. And we just talked about why you can't come to that conclusion based on that data. What happens then is Dr. Ngo, remember the gentleman who's in charge of peer review, takes over the inquiry. He says, this data is not risk adjusted. I don't think it is really telling us anything. What you need to do when you're talking about surgeon quality is what we normally do, which is peer review. So the peer review committee takes the 4 surgeons, looks at several years worth of cases, and does a comprehensive peer review on all 4 of them to see if there is a quality of care problem with any of them. It takes months, takes 4 months. During the process of going through this analysis, Dr. No comes to the conclusion that for some reason, the administration seems to be trying to do an end around the peer review. The peer review committee, when they look at the information and do a case-by-case peer review, conclude there is no problem with quality of care, that everybody is doing okay, all 4 of them. There is some room for improvement, but there is absolutely, well, Dr. No testified or characterized it as a resounding exoneration of Gomez and the other 3 cardiovascular surgeons from any suggestion that there is a mortality problem. And the peer review committee, speaking through Dr. No, told the administration, this is not useful data. We don't want you continuing to generate this data. We don't think that it is proper. And in fact, Dr. No testifies that if you were to spread non-risk adjusted mortality data about a surgeon that reflected badly on him, that would be atrocious because that so clearly misrepresents the situation.
We're about to run out of time, and I feel like I'm hearing you argue a completely different case than we just heard the petitioner's counsel argue. I mean, I think what they're saying is, even assuming all that's true and that the reliance on raw data is bad and that it can be misrepresenting the actual Their argument is, yeah, but in this record, there's no evidence that any statement that was relying on the falsity of that data was ever communicated to anyone in any way that ever caused your client damages, a loss of referrals. And I feel like y'all are arguing two completely different cases.
I'm sorry, I don't mean to cut you off. There are in some senses, there are two separate narrative paths that are occurring in this litigation. And Memorial Hermann's narrative path is that we had this data initiative, we're trying to improve surgeon care, and it's all benign. Plaintiff's narrative path is there is a reason why this data is being propagated.
I don't think they're saying it's benign. I think they're saying no one ever communicated it to anybody in any way that caused the loss of referrals.
We know that that's not true because of the Aussie Statement to begin with. Brian Aussie tells Dr.
Which was made to Dr. Gomez.
Yes, tells Dr. Gomez.
So where's the evidence that then it went from Gomez in some way to someone else that caused the loss of referrals?
Because what he's telling Gomez is, I have told the cardiologists, I have gotten the data to them because they need to see it to make referral
the statement
choices.
Within a statement theory.
Yeah.
Okay.
And there's no, I don't mean to seem dismissive about this, but there is no problem with the form of the charge at all. The jury understood what was being talked about, and you know that for sure when you look at the jury question, because as Justice Busby pointed out, the jury asks, are you asking us about that statement from a literal standpoint, or are you asking us about the information that he says he was giving to somebody else? Words to that effect. So the jury got it, that there's a statement within a statement, and the jury was trying to get some guidance as to what do we look at. And of course, as is typical when you have that kind of problem, the trial court tells the jury essentially, look at the charge, do the best you can. But what they end up deciding is that we are, clearly, because otherwise it doesn't make any sense, we are making an evaluation of, was the statement that Gomez had high mortality that Aussie admits that he's made, were they defamatory?
So even if you're right about all the flaws in the metric that you were discussing, do you also have to show that the speakers agreed with you that the metric was unreliable and then made the statements anyway? Is this about their state of mind? And if so, what's the evidence there?
The state of mind can be only recklessness. In this set of circumstances, though, because you have the peer review analysis and a specific instruction from the peer review folks through Dr. No to stop using the data, they do have mens rea. They know that it's bad. If they were under any impression prior to
they know other people think it's bad, but do they agree that it's bad, or is that not the standard?
It is not the standard in a defamation case that the person making the defamatory statement has to agree that it's defamatory. Or
has to know that it's false, right?
Yes, and we do know that they knew, if at no other point in time, after that peer review analysis was made of the very same data that had been subjected to the individual surgeon mortality index, individual surgeon mortality data, and the peer review committee had told them specifically, we don't want to be using this data. This is an inappropriate way to evaluate medical care. It's just not fair to the surgeons. And the testimony goes somewhat further than that. I think I'm running over rather massively here.
You can finish your thought.
The testimony goes somewhat further than that because the person who's running that peer review specifically testifies that he felt that what was happening is that the administration was deliberately manipulating the data in order that Dr. Gomez be treated differently than he would be treated if he was given an objective analysis of the kind of care that he had been providing.
Any other questions? Thank you, Mr. Lee. Ms. Pfeiffer, I believe you have 5 minutes.
May it please the court. Justice Boyd, you accurately characterized our position, and we did not hear any answers. We are ships crossing in the night, and the challenge we have in this case is that we just heard a lot about statistics and data, and standing here today, I don't know what data we're talking about, because we're talking about years worth of data in this record that changed over time. Justice Huddle, you asked about it being blinded, and I've included 2 examples of data in the bench exhibits that both show blinded data. I've got the first data presentation that was ever presented and one of the last data presentations. They're very different. They're blinded, and everything you heard from Mr. Lee today is about data that was presented in privileged meetings. He's referring to statements made and data presented in these statutorily privileged meetings, which is why this is not what's in the jury charge. They were trying to find something outside of a privileged meeting to put in the jury charge to overcome our objections. And Justice Busby, if I could return to your question about objections to the charge, we all agree the charge doesn't have any form problems. We had a 12-hour informal charge conference with 4 board-certified appellate lawyers, including the trial judge, the plaintiff's lawyer, and 2 lawyers on the defense side.
And the trial judge rewrote your question, right? That's how we ended up with this?
No, this question was the parties' agreement. At volume 15 of the reporter's record, page 8, Judge Moore, during the jury deliberations, when the jury's asking about what does this Aussie Statement mean, he recalls the lawyers agreed to this statement. They agreed to go back to the quoted testimony. And the reason the plaintiffs were willing to do that is because if they didn't have something specific, we had all sorts of objections. We had limitations, we have the privilege issue, we've got the fact that all through trial, Judge Moore had been saying you need to identify a speaker and specifics. And so this was their way to overcome all of our objections in this 12-hour informal charge conference. This is what they came up with.
But don't we have to interpret it possible, the charge question and the jury finding, to avoid nonsensical results and in a manner that upholds the judgment?
That proposition comes from cases where jury charges are ambiguous. And
the jury seemed to think that this one was ambiguous.
The jury may have thought that, but I think the parties agree, and the court can look at it and say it's not ambiguous. Now, it's legally insufficient and fatal on its face, but it's not ambiguous. So, the fact that the plaintiffs put something in the jury charge that just doesn't work is because that's all they had. They didn't have something more specific to put into the charge. This case reminds me a lot of the court's recent decision in Burbage versus Burbage, where it's a defamation case and the plaintiff was trying to prove that defamation caused customers to cancel contracts. And they were asked, well, did you ever ask any of your customers why they canceled a contract? And they said no. They didn't actually go do anything to confirm that defamation caused the harm. Dr. Gomez, he knows who his referring surgeons or referring cardiologists are. He could have gone and asked any number of them, have you changed your referral patterns, and is it because of hearing any data? And he had 0 evidence on that. And everybody that we asked, as the defendant, we asked that question and got positive answers in our favor, saying no, they hadn't changed their referral patterns. So it's very much like the court's decision in Burbage versus Burbage, in Hancock versus Varium, and in Brady. These cases say the harm has to be more than theoretical, and you actually have to show that defamation reached listeners who not only believed it, but changed their opinions based on the defamation. The plaintiffs just don't have that. This case has been a lot like trying to nail Jell-O to a wall. We don't know what the defamatory statements are if they're not what's in the jury charge. And we can't defend ourselves if we don't have specifics. Judge Moore agreed with that, and that's why at the beginning of this case, he was telling the plaintiffs, you've got to have specifics. It can't just be a whisper campaign. It can't just be rumors. We have to know what the statements are. And so I submit the only way to review a case like this, a $6 million defamation and business disparagement judgment, is to review the statements in the charge and hold them legally insufficient. Thank you.
Any other questions? Thank you, Ms. Pfeiffer. The case is submitted, and the court will take a brief recess.
All rise.
Please be seated. We'll hear argument in 2639, Nettye Engler Energy against Bluestone Natural Resources.
May it please the court. Mr. Pennington will present argument for the petitioner. Petitioner has reserved 8 minutes for rebuttal.
Morning. May it please the Honorable Supreme Court of the State of Texas. My name is Alan Pennington, and I'm here representing Nettye Engler Energy. This case involves the interpretation of a non-participating royalty interest reserved in the 1986 deed, which conveyed surface and reserved some minerals. The grantor who reserved the royalty, my client is a successor of the grantor who reserved the royalty. The question for the trial court is, what is the meaning of the phrase "free of cost in the pipeline, if any, otherwise free of cost in the mouth of the well"? There were cross motions for summary judgment filed in this case, and the trial court, Judge McCoy, granted Engler's motion for summary judgment, finding that that particular reservation was free of certain post-production costs. Judge then had a second hearing in which she determined which post-production costs were exempt from the royalty, were exempt for that particular royalty interest. She noted that in the deed, in the 1986 deed, 2 different valuation points were expressly envisioned. She also noted, if you'll see the exhibit, that there is an otherwise language, a disjunctive word, which she held determined that valuation could not be at the mouth of the well because of the existence of a pipeline. In granting Engler's motion for summary judgment, the trial court relied on the expert testimony of Patrick Murphy, who I contend is the top oil and gas attorney in Tarrant County, who stated that in the 1986 deed, the term pipeline meant the transporter pipeline, not the gathering system, as was being urged by Bluestone. Patrick Murphy's testimony was not contested by any summary judgment evidence. Any objections to his statements in a 3-page affidavit that he filed in support of our motion for summary judgment were waived. The reason I say they were waived was because there were only vague objections made to his 3-page affidavit. Those objections were expressly overruled by the court. And at that point, in addition, there was no summary judgment evidence whatsoever offered by Bluestone on the meaning of the term pipeline in this reservation. So the case went up to the Court of Appeals. The Court of Appeals expressly agreed that the phrase "free of cost in the pipeline, otherwise free of cost at the mouth of the well" had to be interpreted and harmonized. In other words, she agreed with both parties that language had to be interpreted and considered. She also, the Court of Appeals also agreed in its opinion that the deed specified 2 different valuation points, 2 separate points. And I would note that in the response brief on the full briefing in this court, Bluestone does finally admit, and I don't believe they had before, that the 1986 deed specifies 2 different valuation points. But the Court of Appeals, after recognizing that it had to consider all the language and that there were 2 different valuation points, it determined that the valuation was to be at the mouth of the well, despite the fact that all parties agree that there is a major pipeline from which the gas from these 34 wells goes. And I believe, if reading the Court of Appeals opinion, that the emphasis of the Court of Appeals was a reliance on the Burlington decision from this court. The Court of Appeals basically said, never mind the 2 valuation points. Burlington says if you have language in a deed that says free of cost in the pipeline, Burlington prophylactically says that means that you value the gas at the mouth of the well. In doing so, the Court of Appeals ignored the 2 valuation points and basically said that the gathering system and the pipeline are really the same thing, that they're synonymous. After the Court of Appeals decision was rendered, Bluestone appealed, I'm sorry, I should point out that in the Court of Appeals reversal, in the original brief of the Bluestone, there was no mention at all of Mr. Murphy's opinion on which the trial court based her opinion. They didn't challenge Mr. Murphy's statement, his opinion that the word pipeline refers to the pipeline, the major pipeline, the transporter pipeline, not to the gathering system as contended by Bluestone. And there was no point of order raised on that at all. In addition, and more alarming, was the Court of Appeals did not even mention Mr. Murphy's statement and his opinion. So there was no point of error raised. The word Murphy does not appear in the appellant's brief filed in the Court of Appeals, and it also doesn't appear in the Court of Appeals opinion. So I believe the real question before this court boils down to what is meant by the term pipeline in the phrase free of cost in the pipeline, otherwise free of cost at the mouth of the well.
And there are two, right? Two pipelines. Two pipelines.
There are two major pipelines.
And whichever one it is, the royalty is different.
Whichever one it is, whichever one it is, our position is it's free of cost till it gets to that pipeline. That was also Mr. Murphy's position. Now, that was not a legal opinion that he supplied. He basically saying, and he's been practicing law as long as I have, since 1981. He's been an oil and gas lawyer for all that time. He's board certified. He says in his affidavit, at the time this 1986 deed was executed, that pipeline did not refer to the gathering system. It referred to the pipeline.
Would pipeline refer, though, to a third-party pipeline that the lessee doesn't have any control over? In other words, is it a fair inference to say that pipeline means any pipeline, including, envision a whole series of pipelines before the gas is sold, owned by various entities? Would it be a fair inference to say that a third-party pipeline is the pipeline that's being defined in the 1986 deed?
Perhaps, Justice Bland, perhaps that issue could have been raised by summary judgment, but I'm pointing out that there was no summary judgment evidence offered to contradict Mr. Murphy's statement of what that term meant in 1986. And so it's Bluestone's position that refers to their gathering system, which is on the lease, and it was our position, and we're the only ones that supported it with summary judgment evidence, that in 1986 that would refer to the pipeline, the major pipeline that goes, I suppose, to the Gulf of Mexico. And as Justice Heck points out, there are two of those. Okay? So it's not a question, along those lines, it's not a question, Justices, about whether the gathering system consists of pipes. I mean, we all know there's no way to move gas except through pipes or conduits of some kind. The question is, what did that phrase mean in the 1986 deed?
And on that, so if we agree that pipeline could be any pipeline, the deed says in the pipeline. Does that really give us a valuation point? Because in the pipeline could be at the very moment it's turned over to the transporter, it's in the pipeline. But then it also could mean the very moment it's, at the Gulf of Mexico being offloaded.
That's exactly right.
So does in the pipeline really help us decide at what point to value the gas?
Well, I guess Judge McCoy's made it easy for you because she said that we have to start paying the post-production costs at the moment it enters the transporter pipeline. So whether the valuation point and sales price is determined at that point or downstream of the pipeline, she ruled that we have to pay those post-production costs, and we don't challenge that on this appeal. As I said, the Court of Appeals opinion relies exclusively on On the Burlington decision, as you know, this court in the Randall case shortly after, also involving Bluestone, said specifically that that case is not a trump card, I think were the words used for in the pipeline, meaning valuation at the mouth of the well. And the court also said in Randall and in Burlington that you have to look at what the parties meant at the time they executed that deed. What did the parties intend? And I believe it's clear that the parties intended that if there was a pipeline, and again, everybody agrees there's a pipeline, we just disagree what it is and where it is, but there is a pipeline, and so that negates, the otherwise language expressly negates valuation at the mouth of the well.
But it seems a little unlikely that the parties would say free of cost in the pipeline, if any, if there's a pipeline sitting out there.
Well, this was done in 1986, and these wells were drilled during the Barnett Shale era, so there would have been no pipeline at that time, I don't believe, Your Honor.
But was the Energy Trust pipeline there at the time?
I don't know, that wasn't developed in summary judgment record.
The gathering system was not there.
Sir?
The gathering system was not there.
The gathering system came along, I believe, after 2010 as well, okay? And there is an emphasis throughout the respondent's brief on the merits on the long distance between the mouth of the well and where the transporter or the main pipeline starts. There is no summary judgment record as to how far that is. It may be, it could be anywhere from 500 feet to who knows. But I would submit that emphasis in the brief is intended to tie into a lot of these cases that they cite where they talk about far downstream from the wells. We don't know how far it is from the wells to the pipeline, the major pipeline. There's no summary judgment evidence of that. So we believe that the situation, I would add quickly that Williams and Myers, which is an authority, of course, on oil and gas, in their 1984 edition, they specifically describe pipeline and gathering system with two different definitions. And they say that the gathering system is the pumps, auxiliary tanks, and other equipment used to move oil and gas from the well site to the main pipeline. So in 1984, that's 2 years before this deed was signed, the Williams and Myers oil and gas terms are saying those are two different instrumentalities. I see that my time is up. Thank you very much.
Any other questions? Thank you, Mr. Pennington. We'll hear from the respondent.
May it please the court, Mr. Clinton will present argument for the respondent.
But before I get into my presentation, I do want to say, may it please the court, that it's important to point out a couple of falsities, just outright falsities in what you just heard. It is outright false that Patrick Murphy's testimony was the only expert testimony in the record. Professor Pam Burney also was an expert testimony in the record. There were dueling experts telling the trial court what the meaning of the deed was. Specifically, the court can go to page 394 and 395 of the record where Professor Burney was specifically asked about the meaning of the word pipeline and whether a gathering pipeline counts as a pipeline. And she said it has no matter that it is the first time it enters a pipeline. So that is outright false, that it's the only testimony in the record. There were dueling expert opinions. Mr. Murphy himself also contradicted himself because his initial testimony. So what happened here is he had a deposition. In his deposition, he said, it doesn't matter. I don't give any meaning to the words pipeline. It doesn't matter which pipeline it is. It could be a big pipeline, could be a little pipeline. His testimony that contradicts the stance that later came in his affidavit is on pages 331 and 332 of the record. And so he actually controverted his own testimony.
Is the meaning of this a fact question?
No.
So
it doesn't matter.
Do we just look at this expert testimony as legal briefing, basically? I mean, it doesn't make any difference, does it?
Absolutely, that's correct. It doesn't matter. We have dueling experts telling the court what these words mean. Those are not fact. That is not a fact. Those are legal conclusions. And legal conclusions...
Unless it's ambiguous.
If the court determines that, yes, if the court determines that the wording itself is ambiguous, then we can start bringing in all of this stuff. Of course, then it couldn't be decided on summary judgment, I guess. The whole thing would be sent back. But it's not ambiguous because we know what a pipeline is. And we don't look to expert testimony to tell us that something is ambiguous.
So how do we know that a gathering system, which is not just pipes, but also pumps and tanks and other things that go along with that, is a pipeline? How do we know that is a legal matter with no ambiguity?
Well, we know it's a pipeline because it meets the definition of the word pipeline. The initial pipe that it goes into on the lease is a pipeline. It's a gathering pipeline. And it's also false that Williams and Myers didn't consider this a pipeline. And Williams and Myers specifically says that includes within the definition of pipeline within the definition of pipeline, a gathering pipeline. And then if you go down the road and look up what the definition of a gathering line is, it says that it's a subterranean natural gas pipeline. So the word pipeline is not ambiguous. And we only by learning that this law expert tells us something differently, that's the only thing that creates an ambiguity. But in Barrow Shaver,
except that the deed uses the mouth of the well and in the pipeline as two different things. And so why doesn't that reading just change the deed to say free of cost at the mouth of the well, period, full stop?
because there's a difference between them. I mean, we can see there is a physical distance, depending on the substance. There can be a physical distance between the wellhead and the pipeline.
Even if there's pipe in between those 2 points?
Well,
a line of pipe between the well and the gathering system?
Yeah, there can be a distance between the place where it enters the first, as Justice Bland said, the first place that it starts putting it into pipeline to move it off the lease. And that's essentially, I mean, Burlington is very, very similar. Burlington had a royalty clause that moved it slightly adjacent to the wellhead and slightly away from the wellhead. And that was at the tanks, receptacles, and in the pipelines. The way that for oil, the way that oil works is that you have to take it to a tank first because you have to remove the water. Gas comes off the top, water comes off the bottom. You have to remove the water. And then you can put it into a pipeline for transportation off the lease. The way that gas works ordinarily is that it can go straight into a pipeline. So, and as I think the Texogo brief well pointed out, this was oil, gas, and other minerals. So in the instance of other minerals, it wouldn't even go into a pipeline at all. If it's coal, if it's uranium, it wouldn't go into a pipeline at all.
That's why it says or mine, so I assume that takes care of that part of it.
Well, if there is a pipeline, that's where we start. If there is not a pipeline, we go to the well or mine. So the primary choice of the parties to this initial instrument was we'd like it to go into a pipeline if there is one. If there isn't, then we take it.
Well, but there's going to be a pipeline.
Well, that of course.
The only question is, are you going to measure it before processing or after processing?
There's not always going to be a pipeline because in the case of coal, there wouldn't be a pipeline, right? This is oil, gas, or other minerals.
Well, but if it's gas.
That's right. In gas, it's going to be done by pipeline. In oil, it might not always be done by pipeline. It might be trucked, as in several of the cases that are cited. What these parties were doing, where they were saying, look, we have a pipeline preference. We wanted to put in the pipeline. That is, especially in the case of oil. Remember, we didn't know what the minerals were going to be because this deed was authored and executed in 1986 prior to this being a developed area. So we didn't know what minerals were going to come. But what we'd like you to do is put it into the pipeline if there is one. And that pipeline is near the well, just as exactly what this court said in Burlington, that those words in the pipeline mean at or near the well. But I think it's also...
You're agreeing, it sounds like, that if somehow factually the pipeline were a distance away and there was a lot of processing in between the well and the pipeline, that those costs would not, under this reading, those costs would not be charged to the royalty holder?
Well, precisely. I mean, and that's the case of oil. The oil has to be processed on site before you can put it into a pipeline for transportation off of the lease. So in the case of oil, you have some processing. You have to take the water out of it. So there are tanks, and this is, again, what you were writing about in Burlington.
I'm just clarifying, you're not equating into the pipeline with at the well in all cases?
Not at all. In fact, we're not equating them at all. We're saying that if there's a pipeline, it has to go in the pipeline. If there's not one, it's an at the well delivery. Now, I do think this is critical, because I think one more falsity. The plaintiff told you that the Court of Appeals has specifically read out in the pipeline, and the Court of Appeals says no. We say that if there's a pipeline, it goes into the pipeline. If there's not a pipeline, it's at the well. So the Court of Appeals did understand that they were two different places. The key to this case, I think, is reading the plain language of the instrument itself. And the plain language of the instrument itself is not even contemplating valuation, because these parties did not have a monetary royalty. They had an in-kind royalty. If you have an in-kind royalty, you haven't even fathomed that there would be two different valuation points, because the only thing that you've fathomed is that there's going to be an in-kind delivery. So we can look at the words itself. Grantor, its heirs, this is on page 60 of the record. Grantors, its heirs, successors, and assigns own, meaning that they thought they actually owned it, and previously they had said this was carved out of in and under. So this was an odd instrument. But they said they actually owned the stuff. Own and shall receive and be entitled to receive a free 1/8 of gross production of any such oil, gas, or other minerals said amount to be delivered to grantor's credit free of cost in the pipeline, if any, otherwise free of cost at the mouth of the well. As Justice Heck wrote in Hyder, those words, gross production, are an in-kind royalty. And this court has said it many times before in Hager versus Stakes in 1927, and Felber versus Sklar, which is a refused case from Texarkana in 1950. The court has said when you use this in the pipeline language, you're really talking about an in-kind delivery. You are delivering the stuff itself. And what these parties agreed to is if you deliver the stuff into a pipeline, that we are preferring it to be delivered into the pipeline, if any. Now, I think Justice Heck's point is really good. The question that you asked about, was there a bigger pipeline at the time? Was there a transfer pipeline? Of course there were transfer pipelines in Texas somewhere at the time. So the parties couldn't have meant if there's a large transportation pipeline somewhere, because those pipelines had existed for 100 years in Texas. The parties could only have meant if there's a connection on the lease, to a pipeline connection on the lease. That's the only thing that hadn't yet been decided in 1986, was whether there were going to be gathering pipelines on this lease itself. And here we do have gathering pipelines on the lease itself. And so we put the stuff, the actual gross production, which is what these parties wanted, not a monetary royalty, but the actual stuff, we put it in the ground for the first time on the lease. I think, Justice Bland, your question about what if we had multiple series, I mean, we don't know what the industry is going to do in the future. Back in the 1920s, it would have been one pipeline company that picked it up at the wellhead and brought it to wherever the ultimate consumer would have been. In the 1980s, it's possible, we understand that their expert says that at that point, that the producers had owned the original pipelines that took it later at some connection. Now that's not even true. Now we know, as is the status here, that the producers don't even use gathering pipelines now. Usually that too is a wholly different company that picks up the gas and takes it off of the lease. Same thing with oil. They're not horizontally integrated, these companies. So generally, the oil gets processed at site and then taken off of the lease by a third company who purchase it. Now,
so if it were the case in 1986 that the producers traditionally owned the gathering system, does that affect how we should interpret the word pipeline?
It doesn't, because a pipeline is a series of tubes that transport gas.
So it doesn't matter whether it's first party or third party owned?
It doesn't matter at all. And the courts who have looked at that question too have reached the same conclusion, that it doesn't matter at all who owns it. What matters is it is a tube to transport oil or gas off of the lease. The moment it is in one of those tubes that is intended to transport the oil or gas off the lease, that's the entrance to the pipeline. And this is really important too. The issue here, the core issue, and I think we all agree now, as Justice Heck pointed out, we all agree that the issue is where's the entrance to the pipeline. We all agree that it's free of cost to the entrance of the pipeline. We all agree that the royalty owner bears its proportionate share of the cost after it enters the pipeline. So the only question before the court is, where's the entrance to the pipeline? This is important. Every authority of every kind who has ever talked about this in writings has concluded that in the pipeline is the pipeline on the lease, the pipeline on the ground on the lease. Every single authority cited in both parties' briefs that construes the words in the pipeline in every jurisdiction says that the word pipeline is the pipeline on the ground on the lease. There's not a single authority cited in either brief that says otherwise.
Unless it's oil. You said if it's oil and it goes through a pipe and then it goes to a tank, that's not a pipeline.
What I've said is that the first time that it goes into a pipeline for transportation purposes to take it off the lease, that's what every single authority has understood the words in the pipeline to mean. There are some cases that bring it earlier. I mean, I guess you're right. There are some cases that collapse into the pipeline and say that it's the moment that it goes from the wellhead to the pipeline, even with oil. There are no cases that take it downstream. So the only disagreement in the cases is whether there is any difference between a pipeline and at the well. That's the only the argument in the cases. There are no cases cited in any party's brief that take it downstream, that say that the pipelines on the ground on the lease are not a pipeline. Not a single one. We've cited authority from this court, of course. In Burlington, the court said so. The court said that in the pipeline is a proxy for at or near the wellhead. The court didn't say at. It doesn't necessarily always be at, but it's at or near, which is, of course, the truth when you take oil or gas and you stuff them in the ground in a pipeline. It's going to be near the wellhead. It may be at, as Justice Busby pointed out, but it will always be near, unless you truck it somewhere else. It's possible that you'd have to truck it somewhere else if you didn't have a gathering system, and you still wanted to get it to a gathering system, you might have to truck it. But every authority of every kind, there's not a single cited authority. This is why plaintiff has to falsely try to convince you that the record is undisputed as to what this means. That is not true. The record is not undisputed. Plaintiff's expert himself disputes the opinion. See, what happened here is plaintiffs initially took the position that the valuation point was at the point of sale at the ultimate consumer. And then changed it, that's what the plaintiff's expert first testified to in his deposition. That what I believe, he said, he actually testifies, I'm telling the court what this means. And what it means is all the way at the ultimate consumer. But plaintiff, in the interim, after the summary judgment briefing, changed its position, after the motion for summary judgment, I should say, changed its position and said, we changed our mind. What we now believe is that it's at this arbitrary point at which the gas changes custody between pipeline companies. And so then the expert comes back and files an affidavit, again, after the motion for summary judgment was filed, and says, I still believe that I'm right, that it's the ultimate consumer, but if I'm wrong, it means plaintiff's new theory. So his primary position, their expert's primary position, isn't even what their argument is today. That was his alternative position that he came up with after plaintiffs changed their own view of what this deed meant.
What's your view of the role of the expert testimony here? I mean, it seems like it could be one of three things. If there were an ambiguity, it could be used to try to answer the question of what this meant. I understand your position that there's not. If it could also just be treated as legal briefing or like a treatise, that says here's what it means. And then, there are some cases that say, well, you can look at sort of what is the relevant understanding of this in the community and that sort of thing in order to, if it has a specialized meaning in a relevant industry or something like that. Is that what's going on with the expert testimony here, or is it just like legal briefing?
Well, I mean, I honestly think it's not even legal briefing because this was purported to be evidence. And this court has said time and time again that legal conclusions are not evidence. So it doesn't transform into evidence because it made it into the appellate record. It's still no evidence. No evidence that's 5 years old is still no evidence, right?
But But is it evidence, do you view it as, I mean, you offered it too, so I'm wondering for what purpose?
Well,
if you offered it as evidence, do you think it's evidence of the meaning of, in the relevant community, you know, a specialized meaning, or what is its role?
Well, I would say we only offered it because they designated an expert. So, you know, it's one of those things, well, if the court's going to let it in, we better have one too. Not because we truly believed that it was evidence, but because if the court's going to let it in, we better controvert it, right? Which is their thing they're claiming we didn't, but we did. With respect to answering your second question, this court has said we don't look to expert evidence to define the meaning of something unless we believe it's ambiguous. And so we have to ask the ambiguity question first before we get to the expert testimony.
But in some circumstances, we do look at contextual information to decide whether something is ambiguous. And so I'm wondering if your view is, does this fall in the bucket where we can do that or we can't, and why?
Well, this court said in Barrow-Shaver that industry custom is only admissible for the jury. It said when consideration of evidence as to industry custom and usage is appropriate is a question of fact for the jury and is the province of the jury to weigh witness credibility. So we don't introduce evidence of industry custom unless we've already determined that it is ambiguous. And in that case, it can't be determined on summary judgment anyway. So this would never be appropriate evidence to attach to a summary judgment, because only if it's a fact question, only if it's ambiguous and therefore a fact question, would we look to it to determine. So the question then, I guess at the end of that is it ambiguous? Because we know that all the precedent, all the regulations, all the statutes, all the CLE presentations, all the law reviews, all the treatises, everything says that in the pipeline is at the entrance to the pipeline on the lease. So is there some ambiguity despite the uniform conclusion of every analysis of this? No, because there's no ambiguity as to what the word pipeline means. And I would go to the very definitions of pipelines. The Webster's definition of pipeline is a pipeline is a line with pumps, valves, and control devices for conveying liquids, gases, or finely divided solids. So the ordinary definition outside of the oil and gas industry is a tube that stuff goes through. Williams and Myers defines a pipeline as a tube or system of tubes for the transportation of oil or gas. So Williams and Myers, the industry definition, is the same. There is no definition of pipeline. There is literally no definition of pipeline, of the word pipeline, that would exclude the pipeline on the lease. There is no definition. So the only way you could possibly conclude that it's ambiguous is to have an expert tell you that it's ambiguous. But we can't consider expert testimony to determine that something's ambiguous. That's what Barrow-Shaver says. So outside of expert testimony, if we simply look to the ordinary definitions, both outside and within the industry, in the pipeline means the tube on the ground on the lease.
I guess I'm still having trouble understanding how under the Webster definition of a tube that stuff goes through, the mouth of the well wouldn't also be the pipeline location even in an oil situation.
It's possible to pick up the oil in trucks at the wellhead. It's also possible, and also in the case of other minerals like uranium or coal, it would never go into a pipeline.
Any other questions? Thank you, Mr. Clinton.
Thank you.
Mr. Pennington, you have 8 minutes.
Thank you, Your Honor. At the time that Patrick Murphy's deposition was taken, Bluestone had not taken the position that the gathering line was a pipeline. They had previously taken the position that since they were not affiliated with the gathering system company, that they could charge. So everything changed after these depositions were taken. After Mr. Murphy tendered his affidavit, there was no request to take his deposition. And the only statement that we were relying on in his affidavit in this court today, the only statement is not a legal conclusion at all. It is his statement that based on his experience that in 1986, pipeline meant the main pipeline, the transporter pipeline. Now, I have not seen or heard of this reference to to Professor Burney's statement. I'll have to look at that back at the office because I've never seen that cited or used in response to the motion for summary judgment we filed in the trial court. But I do know that when I took her deposition, this wasn't even an issue. This is a gathering pipeline, a gathering system of pipeline. It also was not an issue when Mr. Murphy's deposition was taken. But how do they get to this point? What do they have to do to get to this point to say that they can call the gathering system a pipeline? What they say is, if you look closely, they're saying, okay, there's two valuation points, but Bluestone may incur costs between the wells and the gathering system, but it doesn't charge for those. So what Bluestone is telling this court is that they can manipulate the valuation of our gas, our 1/8 of the gas, back to the mouth of the well simply by not charging Engler these costs that it incurs between the mouth of the well and the gathering system. And of course, going along with that, they have to come up with a new name. And the new name that they've come up with for their gathering pipeline in their motion for summary judgment that they filed when they changed the whole stature of the case was it's now called a gathering pipeline. So that's what you're faced with. As far as the definitions in Williams and Myers, I stand by what I said. The reference that counsel made to oil pipelines, including gathering lines, specifically is related only to oil pipelines. Separately, following that, Williams and Myers define, say in the case of gas, the gathering system delivers the gas to the main pipeline. And then I already gave you their definition of gathering system that takes it to the main pipeline. So I want to talk about Mr. Murphy's opinion, the only one we rely on, which is not a legal opinion. Basically, we are not relying on his testimony early on that he said that this was entirely cost-free. We abandoned that. And the court held what she held, that we're free of cost up until it gets to the pipeline. We say that's the main pipeline. Again, there was no objection made to Mr. Murphy's statements except these global objections. There's 3 global objections to a 3-page affidavit. Those were overruled.
Counsel, what's your position on this question of what is the court supposed to do with expert testimony about the meaning of a contract when neither party is contending that the contract is ambiguous?
I was just getting to that, and the answer is that this court has said many times that Justice Busby points out that if there is a technical term in a contract or a deed or so forth, that expert testimony, if that's what this is, and I think Mr. Murphy's statement is more in the way of fact, but it can be relied upon. And I'll give you several examples. This court's case 2007, Exxon versus Emerald Oil. They took an expert definition of the term drilled and completed with regard to an unambiguous contract. Tittiser versus Union Gas, this court, Texas 2005, allowed testimony as to the meaning of the word pooling and what was recognized as an unambiguous contract. I
guess my question, does it make a difference that this is testimony, or would it be of equal value if you just put a citation in your brief to a CLE presentation or some other place where this guy had said these things?
I believe, Justice, that it's not an opinion at all. It's not a legal opinion. He's not expressing a legal opinion that as to what the effect of the main pipeline being referred to as the pipeline in the industry. That's not a legal opinion, and so he is simply testifying essentially as a fact witness with expertise as a board certified oil and gas attorney as to this is what is meant. And I'll mention a couple of other cases. The Barrow Shaver case, which counsel just mentioned.
If he's an expert, would it be a factual opinion? Is that, if it's not a legal opinion, but he's testifying as an expert?
It's a factual opinion, sure.
He's saying, this is my understanding from...
No, he's saying that in 1986 when this deed was executed, pipeline didn't mean gathering system. And I don't think pipeline means gathering system now. I think if you send a guy out and say, you need to go work on the pipeline. He's not going to go to the gathering system. And so the Barrow Shaver case was mentioned. That's a case from this court 2 years ago. And the court in that case says that industry custom and usage absolutely may inform the court of the meaning of industry-specific words. These are not exact quotes. Custom and usage is often involved to shed light on the meaning of oil and gas-related contract provisions such as those found in leases, farm-outs, and operating agreements. And they could have added oil and gas deeds if they'd wanted to. And so you cannot use this type of testimony by an expert to alter or add to a document, but you can certainly use it, as this court has said 3 times in the last few years, to inform you as to what a specific industry term means. And that's exactly what Mr. Murphy did. And because they did not object at all and even mention Mr. Murphy's statement that the court relied on until their reply brief in the Court of Appeals, Rule 38.3 of the Texas Rules of Appellate Procedure says that point is waived. So that's what you have at this point. You have, I believe, because this was not an issue when Professor Burney's deposition was taken, I think all you have is Mr. Murphy's statement that in 1986, pipeline didn't mean the gathering system. And I've demonstrated how they have to manipulate their calculations and so forth to even claim that it is. So in summary, this court said in Burlington that we have to look at what the parties meant when they executed this deed, and that's what Judge McCoy did. What the Court of Appeals ruled, in effect, is to say, they rewrote the deed to say, I want to read this right, that the phrase free of cost in the pipeline, if any, free of cost at the mouth of the well, really means free of cost at the mouth of the well if there's a pipeline, otherwise free of cost at the mouth of the well. The Court of Appeals ignored the 2 valuation points and held that it's still, no matter what we say, it's still at the pipeline because of Burlington. So we would ask the court to reinstate the trial court's grant of summary judgment in favor of Nettye Engler Energy. I very much appreciate the attention and the questions of the court. It's an honor to be here.
Any other questions? Thank you, Mr. Pennington. The case is submitted, and the court will take a brief recess.
All rise.
Please be seated. We'll hear argument in 2725. Van Dohlen against the City of San Antonio. Justice Lehrman cannot be present this morning, but expects to participate in the decision of the case.
May it please the court, Mr. Mitchell will present argument for the petitioners. Petitioners have reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court. Section 2400.004 of the Texas Government Code clearly and unequivocally waives and abolishes governmental immunity in any lawsuit that seeks declaratory or injunctive relief against a defendant that is alleged to have violated Chapter 2400 of the Texas Government Code. It is undisputed that the plaintiffs are seeking declaratory and injunctive relief against the City of San Antonio for the actions it has taken and continues to take that exclude Chick-fil-A from the San Antonio airport. It is likewise undisputed that the plaintiffs have alleged that the city is violating Chapter 2400 of the Texas Government Code. It is therefore impossible to escape the conclusion that Section 2400.004 waives the city's governmental immunity and allows the plaintiff's lawsuit to proceed. The Court of Appeals held that the plaintiff's lawsuit was barred by governmental immunity, notwithstanding the clear, unambiguous, and unequivocal waiver of governmental immunity in Section 2400.004. The Court of Appeals holding is wrong and should be reversed. The city cannot assert a governmental immunity defense in a case where governmental immunity has been waived and abolished by statute. The court should also hold that the plaintiffs have standing to sue the City of San Antonio over its exclusion of Chick-fil-A. The Court of Appeals did not reach this issue, but the district court did. And the court should not remand this issue back to the Court of Appeals and risk another ruling from that court that defies the clear and unambiguous language of Section 2400.004.
We felt that the plaintiff in some cases has the burden to plead and in some cases even submit evidence to establish a waiver. Even if the generic pleading is a waiver, the facts pled must support that waiver. I'm thinking of the recreational use statute cases. So for example, if I sue the city for striking me with a motor vehicle and therefore there's a waiver under the Tort Claims Act, but the facts pleaded say I was hit by a bicycle, courts are going to look at that and say there's no waiver here because
Right.
the facts undermine it. It's not so much the merits, it is still pleading based, but the pleading defies the waiver. Does that concept apply here for your situation? You've pled this, but the nature of the facts you've pled, according to the city, is you're applying the law retroactively and it fails on the merits, and therefore there's no waiver of immunity.
Right.
Why doesn't that apply here?
Well, everything you said, Your Honor, is correct, but in this situation, all we need to establish a waiver of governmental immunity is an allegation that the city has violated or is violating Chapter 2400.
Even if the facts you plead that support the allegation plead yourself out of that claim.
Well, we haven't in any way pleaded ourselves out
because they argue you're trying to apply it retroactively. I'm not
Yes.
saying I agree or disagree with them. I'm just saying if they're right on that, why doesn't that affect immunity waiver?
If our argument was that the city violated Chapter 2400 before the statute took effect, which is what the city is attributing to us, if that were our argument, and it's not, but if it were, then clearly we would have pleaded ourselves out of court. But
Because of immunity?
well, because
Or
of immunity,
on the merits?
both. I think both, because
Okay, so you would concede that if we characterize this the way the city is, then there's no waiver of immunity. It's
Correct.
not just you lose on the merits, there's no waiver of immunity.
we would have to identify some other waiver of immunity. The
Okay.
only way we can rely on the waiver of immunity in Section 2400.004 is to allege a violation of the statute that occurred on or after September 1st, because the statute was not in effect before September 1st. And this is one issue on which the city and we agree. I mean, the statute is not retroactive. We're all agreed on that point. The city did not violate the statute when it adopted the Trevino Amendment because it enacted and adopted that amendment prior to September 1st, 2019. So we're all agreed on this point. The city did not violate state law by enacting or adopting the Trevino Amendment by a vote of the city council. The violations of state law come from the actions to implement the Trevino Amendment that occur on or after September 1st, 2019.
Are there any?
Well, we have alleged that in our complaint. We filed our complaint on September 5th, so 5 days after the statute took effect. And what we have alleged in the complaint is that the city, I'm sorry.
So we don't know if there are any.
We'll find that out in discovery, but at this point, at this stage of the litigation, at the pleading stage, the allegations of our complaint need to be accepted as true when the city moves to dismiss under Rule 91A. And on the plea to the jurisdiction, all we have to show is an allegation. Because again, if we look at the text of Section 2400.004, all that's needed is an allegation of a violation to get around a governmental immunity defense. Now, of course, you can't just win your case on an allegation. That goes to the merits. That comes later. But
What violation is alleged?
the violation is that they are taking actions to implement the Trevino Amendment. So the statute prohibits any adverse action that is partly based on an entity's support for a religious organization. So any action that is taken to put a replacement vendor in that spot.
But
that
what actions have you alleged?
Well, we haven't specifically alleged actions in the complaint yet because we haven't taken discovery. So we've alleged that they're implementing the Trevino Amendment. We're alleging that they're taking actions to implement the Trevino Amendment. What exactly those actions are will come out in discovery. So who is the replacement vendor? We don't know that yet because there hasn't been any factual development. There hasn't been discovery at this point. The city moved under Rule 91A. The city filed a plea to the jurisdiction before we ever got to that point. But
you can take discovery on a plea to the jurisdiction, but was that not requested by either side in the trial court?
No, it was not, because again, our position on the governmental immunity issue, Justice Busby, is that the mere allegation is enough. If you look at the text of Section 2400.004, governmental immunity is waived and abolished to the extent of liability established by Section 2400.003. And then in the previous sentence, the first sentence, says that any person who alleges a violation of the statute may sue. So that's all that's needed to get into the courtroom door.
It seems like our rules for statute of limitations and accrual and that sort of thing should be considered in the mix of deciding when a violation occurs. And we've said, basically it's when you can sue is when a violation occurs. And so there's not, it's not like continuing tort theories are fairly rare in the limitations context. And so help us understand how your argument fits with that general rule that a violation, just because you're continuing to be harmed by a violation doesn't mean that the thing that you can sue over hasn't already happened sometime in the past.
Yeah, I think with respect to the statute of limitations, Justice Busby, we filed our complaint on September 5th.
No, I'm not saying there's a limitations argument in this case, but what I'm saying is the principles of accrual that govern statute of limitations, it seems like would also be relevant in deciding whether the thing that harmed you occurred before the statute was enacted or after.
I think that's certainly right. We can only sue over conduct that occurred after the statute took effect.
Right.
So again, the statute was enacted before September 1st. It takes effect on September 1st, 2019. There is nothing we can do about any pre-September 1st, 2019 action to obtain relief from this court.
Is there any new injury that occurred after September 1st?
The question, I think, Justice Busby, is was there a new action that occurred after September 1st? We don't have to show injury under the statute. All we have to do is allege a violation of the statute, whether that injures us or not.
So was there a new violation after September 1st?
Yes, we have alleged in our complaint that the city is taking actions to implement the Trevino Amendment. We don't specify in detail what those actions are, but that level of detail is not necessary under a regime of notice pleading. And anything the city does, adverse action is defined very broadly. Any action, typing an email would be an action. Picking up the phone, negotiating with a replacement vendor would be an action. Looking for a replacement vendor would be an action. Any type of movement would be an action. Anything the city did to put a different vendor in that spot that would have gone to Chick-fil-A is an action to exclude Chick-fil-A from a property. It's an action to deny Chick-fil-A a contract. All of that falls within the definition of adverse action. And all of that they all constitute actions on which our plaintiffs can seek relief. Declaratory relief, injunctive relief, plus costs and attorney's fees. But again, the issue here is governmental immunity. That is the issue that the Court of Appeals relied upon in saying that our lawsuit could not proceed. And that is patently wrong because the statute, by its very terms, says that governmental immunity is waived and abolished to the extent of liability created by Section 2400.003. So there's no way to defend what the Court of Appeals said, which is this lawsuit is barred by governmental immunity. And then the only remaining issue in this case is the issue of standing, which the Court of Appeals did not reach. The district court did resolve the question. But the city will say on remand that our clients lack standing. And we believe it's prudent for this court to say right at the outset that that argument is a non-starter for two separate and independent reasons. Number one, the statute confers standing by its terms on anyone who simply alleges a violation of the statute. It's not necessary to show injury in fact. And the city's argument is based on the rules that apply in federal court, where injury in fact must always be shown under Article 3 to establish standing. That's not the rule in state court. In state court, if there's a statute that purports to confer standing on individuals who merely allege a violation, the courts must accept that and confer standing according to what the statute says.
And that certainly was our approach when we had a common law standing regime in Texas before we sort of constitutionalized it and adopted the federal constitutional understanding of standing. But is that still, is some of that common law standing regime still left? And if so, what shows us
Yes.
that?
No, absolutely, Justice Busby. It's still left. I mean, the court's precedents have made clear that if standing is conferred by statute, that the courts are to look to what the statute says with respect to who has standing to sue. In the absence of a statutorily conferred cause of action, then the court would apply the similar test the Supreme Court uses, the injury in fact, causation or traceability, and then redressability. But those three requirements are only needed in the absence of a statutory cause of action that explicitly confers standing on the plaintiff.
The statute doesn't use the word standing or explicitly confer standing, nor does it say anything about injury. It just says any citizen can sue. I mean, am I
That's correct.
about that?
Yeah, the word standing does not appear in the statute.
What if it's not ripe?
Ripeness would be a separate question.
Why?
But
Any
standing and
citizen
ripeness
can sue to, any citizen can sue to seek a declaration or injunctive relief against a violation. That doesn't require ripeness.
I don't believe it does, Justice Boyd. That's right.
So the statute would allow someone to sue even if it's not right?
I believe so. That's correct. As long as they're alleging, they have to allege a violation of the statute. That's enough to confer standing. Again, doesn't mean they win, doesn't mean they get relief, but it's enough to get you through the courtroom door. The mere allegation of a statutory violation is enough, as long as it's done by a person. Any person who alleges a statutory violation may sue. That's all that's needed. Those are sufficient conditions to overcome standing.
Well, it's even a little broader than that because it allows you to seek injunctive relief to prevent a statutory violation.
Correct.
Which is what raises the ripeness issue in my mind here, because you've alleged that they have taken and are taking since September date actions, but not alleged any specific actions. There could be a ripeness issue here. There could be some question about whether, well, they intend to or they're thinking about it, but they haven't done it yet, right?
Yeah, there could be.
It raises
right.
a ripeness issue, and it would be your position that this statute allows them to sue even if it's not right.
Well, it allows them to have standing to sue. That doesn't mean they get the injunction, right? There are many other ways they may be denied relief ultimately at the end of the day. And one way, in order to get an injunction, you have to show the harm is imminent, or you wouldn't show harm to yourself, but you would have to show the statutory violation is imminent. And if there's a lack of imminence, then there would not be a basis for issuing the injunction. You have to show essentially either a past violation, a present violation, but if you are alleging a future violation,
the statute doesn't require ripeness. It doesn't have to, the statute doesn't require an imminent violation. It just says you can sue to stop a violation.
That's true, but there are rules governing injunction.
Constitutionally, we know that we have to impose the ripeness requirement so that we're not issuing an advisory opinion when in fact there's not about to be a violation, right?
Oh, that's right, yes.
The statute doesn't change that, so why does it change the standing requirement? It doesn't say you can do it even if there's no standing.
Yeah, but Your Honor, with respect, I don't think the issues you're discussing go to issues of ripeness or standing. It goes to whether you're ultimately entitled to an injunction. I mean, there's a well-defined standard for getting an injunction. You have to show that they're about to violate the statute. You can't just do it based on rank speculation. That wouldn't be an issue of standing. That would be a question of whether you're ultimately entitled to get the injunction. Because, again, this is a citizen suit provision, right? It's not requiring you to show an injury to yourself that the court will redress. It's a
Let me
provision.
ask you about that, because it does, should or shouldn't we interpret a person in 003 as a reference to the person in 002 against whom an adverse action is taken? Because it seems like, at least the other side's argument is that's the legal interest that the statute is protecting. Is you've been an adverse action has been taken against you because of your support to a religious organization.
Yeah, I just don't think, Justice Busby, that's a plausible reading of the statute. And again, I'm looking at the language itself in section 2400.004. It just says a person who alleges a violation. It doesn't say the person who suffered an injury or the person in 2400.003. There's no cross-reference in the statute. A person means any person. It doesn't have to be a specific type of person or any type of individual who's had an injury or is any way affected by the statute.
But that a person who is not the person in 002 can't get declaratory or injunctive relief, it would seem, without at least making the person who was injured under 002 a party to the case.
May I answer? I see
Yes.
my time has expired. Justice Busby, there's no need at all to make Chick-fil-A a party to the case. This is a citizen suit provision where the entire citizenry essentially has been authorized to bring civil actions against individuals who violate this law. And that's the enforcement mechanism.
So the trial court could enter an injunction saying you have to, against the city, saying you have to put a Chick-fil-A in there, even if Chick-fil-A were to say, we don't want to be in there anymore.
So that's an interesting question, Justice Busby. To get back to your earlier question about whether Chick-fil-A has to be a party, Chick-fil-A does not need to be a party because the injunction is not directed at Chick-fil-A. The injunction would be directed at the city itself. So as long as the entity...
But it affects Chick-fil-A's interest.
It does affect Chick-fil-A, but they still don't have to be made a party because Chick-fil-A is not being told to do anything by the injunction, right? Chick-fil-A is not being said to operate an airport in the city of San Antonio on pain of contempt. It would be the city to whom the injunction is directed. Now, again, Justice Busby asked the second half of the question, what would happen if Chick-fil-A says, we don't want it? The question would then become, is there an adverse action? Because if Chick-fil-A doesn't want in, they really haven't been excluded, or they're not presently being excluded by a city that says, we don't want you anymore, right? So the key word in the statute is exclude. Now, if Chick-fil-A was excluded prior to that point, we still would have a cause of action under 2400.004. And I'll save the rest of my time for rebuttal.
Any other questions? Thank you, Mr. Mitchell.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Lane will present argument for the respondent.
May it please the court. It takes more than just to shoot first and ask questions later to trigger the waiver of immunity under this statute. Before I wade into the thicket of issues related to standing, I want to suggest in two simple steps why this court should affirm the Court of Appeals decision. First, we like Section 2400.004. It's Exhibit 1. I've distributed it so that you can look at it. It provides a limited waiver of governmental immunity. It's Exhibit 1 for your convenience. In substance, it says a person who alleges a violation of Chapter 2400 may sue for the relief provided under Chapter 2400. Enough said. Key language, a person who alleges a violation may sue. To quote the Chief Justice in the City of Laredo, we must take statutes as they are written, and the one before us is written quite clearly. Second step, let's look at the original petition that plaintiffs filed. It is the test for the standing and for the violation and for the waiver, and it's also been marked as Exhibit 2 and distributed. The factual allegations in the petition are found at paragraphs 20 through 47. They begin in 2011 and they end in March 2019 in paragraph 47, where it says the council voted to approve the airport contract. That's the last factual allegation in the petition. By the way, it's not enough to allege violations as a legal conclusion. The factual allegations end before the 6 months or more than 5 months before the effective date of the statute. The plaintiffs concede that vote.
Does the city disclaim an intention of enforcing the contract in the future?
Disclaim an intention of enforcing the contract.
I mean, their position is we're alleging that you're going to take actions in the future. You intend, there's a threatened violation by the enforcement of this contract. Is your position factually, no, there isn't? Or is your position just, well, they haven't alleged that with enough specificity?
I will tell you that the city of San Antonio will comply with Chapter 2400 in every step it takes. Now, what the plaintiffs want you to believe is there's only one step that can be taken, and it requires a violation of Chapter 2400. But there are a multiplicity of steps that can be taken. For instance, the city of San Antonio could go back to Chick-fil-A and say, would you like to take the slot that was denied you in that vote in March of 2019? That would not be a violation of the statute. If Chick-fil-A was not available, the city could attempt to fill that vendor spot, mindful of its obligations under 2400, not to discriminate against anyone on the basis of their affiliation with or support for a religious organization.
If I ask it differently, their position is, your intention is to carry forward with the exclusion of Chick-fil-A. Is your position, no, it isn't?
No, it isn't. Absolutely not, Your Honor. As a matter of fact, since you've asked, it has been reported, and it occurred, that the city of San Antonio went to Chick-fil-A and said, would you be interested in coming into the airport and having the slot that was denied you in the vote? Now, that is not something that the city should have to prove at trial. It has immunity from suit. And so the fact is, yes, it was offered to Chick-fil-A, and now the city has to go forward not violating 2400 and find a replacement, mindful not to violate.
Just to be very clear, the city concedes that its ordinance is invalid and unenforceable to the extent it would permit the city or require the city to take an adverse action based on Chick-fil-A or any other entity's affiliation with contribution and so on. You agree the ordinance is invalid and unenforceable?
The ordinance was an approval of the contract between Parodies and the city with sub-concessionaires. It was approved on one date. It's not a ban of anyone. The city can turn around and get Chick-fil-A and have Chick-fil-A come in anytime it wants to and approve that contract. It's not a ban like in the city of Laredo. In the city of Laredo case, that was a situation where the city of Laredo passed an ordinance basically banning single-use bags at shops. The argument was that ordinance was precluded by a statute that had been enacted 15 years before. And before they actually started to enforce the ordinance, the Laredo merchants came and said, we want to get an injunction because this is a void ordinance. And here, they haven't argued that this ordinance, that this approval of a contract, not a ban, that this approval of a contract was void at the time it occurred.
So was this factual question of whether you intend to continue to exclude Chick-fil-A developed at all in the trial court, in the litigation on the plea of the jurisdiction?
No, Your Honor, and the reason why is, first, because the petition that was filed does not trigger the waiver of sovereign immunity, and therefore the city shouldn't have to defend itself. It's immune from suit. But the plea to the jurisdiction was based on the filing. That is still the filing, and was still the filing 4 months later when the court had the hearing and the ruling. There's never been an allegation, and it was even today, there's no allegation that the city has violated. And the fact is, there are numerous different ways. Let me, if I can, illustrate with an analogy. Let's say you, like me, drive to work every day up a street. You go through a cross street. It has no stop sign. Every day you've been doing that for years, like I have. Today, let's say this afternoon, the city installs a stop sign there. Tomorrow you get up ready to go to work. Before you even leave your porch, you're being ticketed for running the stop sign. Is that fair? The argument being, well, you've run that stop sign, you've run that intersection every day for the last 5 years. It's inevitable that you will do it again today. Well, there's a stop sign there today. You have a lot of choices. You can go the other direction, you can walk, you can Uber, or you can just come up to the stop sign and stop. And that's what the city of San Antonio will do. It has read Chapter 2400, and it will not award a contract that is not mindful of Chapter 2400. And if it's Chick-fil-A that wants to come in, Chick-fil-A can come in. There's no restriction on Chick-fil-A coming in.
And if it did, immunity would be waived from suit.
Only immunity is waived if there's an allegation of a violation of the statute.
No, you said the city will comply.
Oh,
but
yeah.
If they didn't,
Yes, Your
immunity
Honor.
would be waived.
Yes, Your Honor. If they said, we don't want to have this, specifically this entity here because they are affiliated with a religious group, and therefore we're kicking them out, and someone brought a petition the next day and said, we allege that they did it on this basis, that would trigger 004.
So the dispute between the parties here is not about the effect of the statute, whether it waives immunity, whether it prescribes behavior that it prescribes, but the only dispute here is with respect to this filing 4 days after the statute took effect. Can we be in court and argue about it?
Yeah, I mean, I would say even more fundamentally, we're in agreement on a lot of things. The vote didn't violate any law, okay? And to the extent that it cost someone the possibility of a Chick-fil-A sandwich, it was a lawful deprivation. That was the status quo ante.
It seems if your reaction to this case is we have no further intention of excluding Chick-fil-A and we agree that doing so would violate the statute, then it strikes me that maybe we need to remand to the trial court so that you can say that, and then that can be binding on you, or maybe the statements you're making in court today are binding and we can just say you've conceded that excluding them would violate the statute, and so we're done here.
Your Honor, let me be very clear. You're suggesting that we would have to defend the suit in the trial court. And our position, the city's position, is that the waiver of sovereign immunity has not occurred.
Well, but it would have occurred if you had a future intention of continuing to exclude Chick-fil-A for this reason. And you're saying, and your response to that is we have no such intention. Chick-fil-A is welcome. And
I can say that
I can see how that might end the case, but only if you're willing to commit to it.
I can only tell you factually, the contract is amended without Chick-fil-A, was approved in March of 2019. In 2020, the Chick-fil-A was asked by the city if it had interest in coming back and having a slot in the airport. This was a matter of public record.
Has that record been developed in the
Chick-fil-A
trial
actually
court?
it has not, because they didn't trigger the waiver of sovereign immunity that would have had us go through trial and have them ask witnesses and actually try and determine whether an actual violation had occurred. What was set up here was
Help me, because it sounds like you're saying the reason they haven't triggered the waiver is because you don't have an intention to enforce the contract.
Not at all, Your Honor. The waiver of sovereign immunity is based on the allegations in the petition.
Which are that you intend to enforce the contract.
What's that?
And the allegation is that you're going to do this. You're going to actually exclude Chick-fil-A.
They actually don't allege any. This court must do a searching examination of the record to determine whether there are allegations that trigger the waiver of governmental immunity. And here, there is no allegation that triggers it. Now, they say we want in the future to stop, and it's based on their theory that there's no possible way, and page 3 of their brief, they say, there's no possible way the city of San Antonio can do anything that doesn't violate Chapter 2400 now. And I'm telling you, there are multiple things that the city can do. This petition fails to trigger the waiver of liability, or waiver of governmental immunity, okay? And so that is our position. The facts that I'm recounting to you are absolutely correct. The Chick-fil-A made a public statement exactly on this point. Now, there are numerous other places nearby that can happen.
There can be discovery in the trial court before the court rules on a plea to the jurisdiction if there are facts that are relevant to establishing whether there's been a waiver or not. And so why couldn't that be done if the allegation here, as it seems to be, is that the city's continued exclusion of Chick-fil-A is based on this, and your point is, well, we're not excluding Chick-fil-A anymore, then why couldn't there be a record developed on that, and either the trial court says yay or nay, there is a continued exclusion or not, and if there's not, then there's no waiver?
Because the city has the right to assert governmental immunity on the basis of this petition, which does not trigger a waiver of governmental immunity. I'm not saying, listen, if we are remanded, the facts will support the city of San Antonio. But the governmental immunity protects the city of San Antonio from having to defend this suit. and they haven't
If-
triggered the waiver of
If they have pled an actual or threatened violation of the statute and sought injunctive and declaratory relief and alleged that the violation was actual and threatened because the city has taken and is planning to take additional actions that violate the statute, but do not specify in their pleading what any of those actions are, does that waive immunity?
That's a lot to chew on, Your Honor. But I would say this, because you said if they say that it has been violated, and then it will be violated. So let's start with first.
Well,
They
let's
have
say
to.
has been after the effective date of the act.
Under 004, there has to be an allegation, factual allegation of a violation of the act. There is not here. Now, let me just say this.
But let me be real clear on the question.
Sure.
But what if there were, to your satisfaction, and they say there already is, but what if there was an allegation that the city post-enactment, September, whatever that date is,
September 1
of 2019,
2019.
If the allegation is after that date, the city took actions and is still planning to further take actions that violate the act, and we want declaratory and injunctive relief to stop it, but they never specify in their pleading what those actions are, is that a waiver of sovereign immunity, governmental immunity?
No, Your Honor. There has to be an allegation. It can't just be an assertion of a conclusion like that, or an assertion of an expectancy. There has to be an allegation. Otherwise,
How do you respond to Mr. Mitchell's point that these are notice pleadings, and I suppose that the city could specially accept to the pleading and ask that it be more particular in stating facts that constitute a violation after the effective date?
if they were suing me, John Q. Public, okay, that would be enough. But the fact is, to trigger to trigger a waiver of governmental immunity, there has to be an allegation. And the statute here says very specifically, you have to allege a violation. 004. Now, 004 is the key that opens up 003. An allegation of a violation of 002. And you heard many times up here during the first argument, we do not know that there's ever been a violation. We plan to, look for one, and darn it, we're going to find one, we hope. And I'm telling you that that's not enough to trigger the waiver of governmental immunity. And you're going to, if that's...
You signed a contract that says you're going to do X, Y, and Z. And
Yeah.
And their allegation is, we expect you're going to do X, Y, and Z, and we think you can't do that. I mean,
We signed a contract.
that's not enough?
No, Your Honor, that's not enough. That is.
So how can they, without any discovery, without any further, can they get in your head and know what your intentions are and allege? What can they say other than, they've signed a contract that says they're going to do these things, we expect them to, and we want an injunction?
Well, what they don't need to do is rush to the courthouse 3 or 4 days after, with a long petition, after the effective date, before there's any indication that there's ever been any violation. Had they waited until for instance, until it was announced that Chick-fil-A had been asked to come back and to take the slot that had been originally denied it, well, would they even have filed this lawsuit? Certainly wouldn't have. That conduct wouldn't have triggered a waiver.
Has all that happened during the appeal?
Yes, it did, Your Honor. It did after the fact. But the problem is, the problem with this petition infects it before the appeal because it doesn't trigger 004. They don't allege a violation of the act. It's very simple. I want to address in my few remaining minutes the standing issue. This court has repeatedly said that there are standing principles under the Texas Constitution that restrict access to court to those who are actually injured, okay? And advisory decisions and opinions are not permitted. This court has never dispensed with that requirement. And the question is, and the suggestion has been made, well, the legislature can dispense with it, but how does that work? It's a constitutional restriction on governmental action that this court has recognized again and again. Just last year, when
Well, the court said this court said in 1966 that the legislature may grant a right to a citizen or a taxpayer to bring an action against a public body or a right of review on behalf of the public without proof of particular or pecuniary damage peculiar to the person bringing the suit. That was Scott versus Board of Adjustment. And I understand there are later statements of the court that speak of this in terms of constitutional terms, but do we need to overrule Scott versus Board of Adjustment and several other cases in order to agree with you?
Not at all. That's actually the particularized injury is what the legislature can do away with. They can say everybody can sue, bring a taxpayer suit, even though you are affected just like every other taxpayer. The particular, you don't have to show that you are. Usually, when you challenge governmental action, a plaintiff has to show that they are affected by the governmental policy in a particularized way. Okay, that there is different. But when this legislature can say, we're going to dispense with the particularization requirement, but what they cannot do, the legislature cannot do, is dispense with the actual injury in fact. The plaintiff has to show that they're injured by the action. Here, the plaintiff...
There are environmental statutes that allow citizen suits, or those
there's a lot of standing law on those topics
in federal court.
And yes, and Lujan is, Justice Scalia's decision in Lujan is a notable one that this court has relied on, and it says you have to show concrete injury. Okay, so there has been some movement in terms of that, but there are suits, and I'll just say the Transunion case, which was decided 2 months ago. The Transunion case was a case where the Congress had said you have an action if there's a violation of this credit reporting law. And a class of 8,000 plaintiffs brought suit, and they said they violated it. We'd like to get our remedy. And the Supreme Court said, but you weren't harmed. You have to have a concrete injury, and therefore those who even though there is a violation under the statute, you have to show harm, and that's an indispensable element of standing. I would just say a couple of things on the requirement.
I guess my point is we've never had occasion to address squarely these many cases like this one that say that the legislature can dispense with some of the standing requirements.
Particularized.
To square that with some of the later statements that adopt some of the federal standards for standing. And I just wonder, if we're going to try to blend the two, I don't know that we have an option other than to just say it's all been wrong about the legislature's ability to grant standing. I mean, that's one way of blending them, but that's throwing away an awful lot of...
My time is up, Your Honor. May I respond?
You may.
Okay, so there's a floor of injury that everyone must show. There must be some injury. Now, every plaintiff to access the courts must have some injury. Now, when challenging governmental action, usually an individual must show particularized injury. In other words, what you're doing, government, is affecting me different than every other citizen. Because if it affects me just like every other citizen, ordinarily, I just have to vote against you or vote for somebody else. But if it's particularized harm, you've mowed over my property, you've done something that harms me particularly, they can come into court. Now, what the government can do is pass a statute that says we're going to take away the particularized requirement, but it brings it back down to that floor, that threshold, injury requirement. The court can't dispense with that, either in federal court or in state court, because it is a constitutional restriction. Now, the Constitution could be amended to permit it, or our Constitution could be permitted to amend it, but there is an injury requirement. That is not a difference between those two line of cases.
So
they're entirely consistent.
Just to respond briefly, the same case from 1966 says the citizen shall not be required to show that he is personally injured by the acts complained of.
Well, in another...
Seems to be talking about injury generally.
In another...
And we're going to have to... We've got these cases, we've got the newer cases, we're going to have to figure out how to blend them somehow.
Well, Your Honor, if it did say at another point in the case it referred to the requirement to show particularized that there are just numerous case after case. Heckman, N. Ray Abbott, this year, what was it, the Chiropractor Board versus Texas Medical Association. Every one of them has stated the requirement that there be an injury under the Texas courts provision. It's a restriction on governmental action. That I don't believe that case needs to be reconciled with those cases, because I think it really addresses particularized injury. But I think it would be an immense departure to say that this legislature can pass a law that evades the constitutional requirement of showing injury.
Any other questions? Thank you, Mr. Lane. President, you have 5 minutes.
Mr. Mitchell, if I may, the city's council has basically said, we respect the new statute, we're going to comply with it. We have been complying, and we're going to keep complying with the new statute. Is it your client's position that the only way they can make good on that promise is to undo the amended contract?
Our position, Justice Boyd, is that if they took any adverse action after September 1st, 2019, we're still entitled to relief, even if they represent to this court that they will no longer take adverse actions against Chick-fil-A.
Right, but that doesn't address, I'm just trying to understand, does your client think that the city somehow has to undo the amended contract?
No, it's not that they have to undo the amended contract. What we're entitled to from this court would be declaratory relief, injunctive relief, and costs and attorney's fees. Now, the question I think Your Honor is getting at is, what exactly would that injunction say? Like, would the injunction say, go and sin no more, or would the injunction say, go back and undo the previous damage that you did, right? And what I believe the correct remedy would be, Justice Boyd, is to say that any adverse actions that you took after September 1st have to be undone. The contract was entered into before September 1st. So I would not go so far as to say that the court should order the city to undo the contract. What the court should do is order the city to reverse and undo adverse actions that it took to implement the contract.
But you don't know what those are yet.
We don't know what they are yet.
I'm sure there were some, but you don't know.
We're sure there were some. We just don't know exactly what they are. And again, as Justice Bland suggested.
Can you give me an example of what you think it might be?
Negotiating with a replacement vendor would be an example, right? Because they were implementing the new contract that excluded Chick-fil-A. So anything they did after September 1st that would put someone other than Chick-fil-A in that spot would be an adverse action that excludes Chick-fil-A from a property or denies Chick-fil-A access to.
So effectively, they have to undo the amended contract, because what you're saying is you can't do anything that would put anyone in there but Chick-fil-A.
Right. Formally, you don't have to revoke the contract, but I think Your Honor is correct. It would functionally be something that prevents them from being able to implement the contract. But we're not suggesting the court has to. The court can't order the city to rip up the contract.
Implementing a contract, even if, I mean, if I buy a car today and I agree to pay 15% interest in my contract, and tomorrow the legislature passes a law that says you can't charge more than 10% interest, you agree that I'm still bound to pay 15%?
No, well, you would be. We got to figure out exactly what the statute says. If it says going forward, you can't charge 15%.
It's not retroactive.
Right. That's right. So it would be similar to what we have here. You can't go.
The contract's done. It may be illegal now, but it's done.
So the contract is there, but they can no longer collect 15% interest on the contract. You're not entitled, however, to go get back the 15% that you paid.
So you would think that even if it's not retroactive, the law that says you can't charge more than 10% would retroactively change the interest rate I agreed to pay before the law was entered?
Well, I think the way I'm understanding Your Honor's hypothetical is there's a new statute that comes out after you sign the contract, right? That says no more 15% interest, 10% is the max, right? In that situation, the contract still exists, right? The contract hasn't been revoked, but they can't collect the 15% on the contract. Going forward, they can only collect 10.
So you think it would, okay.
Yeah, but you can't go back and sue to get the previous interest you paid before the statute's effective date. And that's similar to what we have here. And I think to get back to your original question, and this is a complicated question of remedies, the only remedy we can get is to undo actions after September 1st. And because the contract was signed before September 1st, that's why I'm answering Your Honor's question to say we're not asking the court to force them to revoke the contract formally, even though I think Your Honor is also correct to say the remedy we're asking for is similar. It's effectively nullifying it because they can't do anything to implement the thing, if that makes
Mitchell,
sense. Yes.
What Texas case would you point us to that says that the legislature can abolish by statute the requirement of any injury at all? I understand the case is about a particularized injury, and you can have we can have taxpayer standing, which the feds don't allow by statute and all of that.
All sorts of things.
But is there any case you would point us to that says the legislature can do that holds that the legislature can do away with any injury requirement at all?
There's a string of cases. I think it's hard to give you just one, but I would start with Spence against Fenchler from, I think, 1903, a very early case.
Right, but that was a particularized injury case, right?
I don't believe so.
Or is that a public nuisance case?
It was more public nuisance, but you did not have to show injury, and the court actually specifically said there's no requirement of injury that needs to be shown because the statute lets anybody sue to enjoin the operation of a bawdy house, I believe it was. But then there's also Scott, which Justice Blacklock mentioned, Scott against Board of...
But that's a taxpayer standing case, right? So there was an injury because you're paying taxes.
There was an injury, true, but again, they explicitly said no requirement of standing. But there's Grossman against Wolf, which is a decision of the Third Court of Appeals that relies on the Supreme Court's precedents. But I think most importantly, to get back to a point Justice Blacklock was making, in most of these courts' decisions, when it talks about the need to show injury in fact, there is almost always a caveat that says, except when standing is conferred by statute. So it's making clear that even though this court is generally adopting the approach of Lujan with respect to the three requirements of standing, they're not going so far as to ban the legislature from conferring standing in situations where the legislature chooses by statute to confer standing on people who are not injured. And there are a couple cases where that caveat is not mentioned. And those are the cases Mr. Lane is relying on to say, look, this court is basically adopting the rule that Justice Scalia set out in Lujan, which is to say that these three requirements of constitutional standing cannot be altered by statute. But the vast majority of cases from this court, whenever they discuss those three requirements of standing, will say, unless standing is conferred by statute, and they specifically accommodate the rulings in Spence against Fenchler and Scott and Grossman against Wolf and those sorts of cases. So again, with all respect, I don't think there's a need, as Justice Blacklock was suggesting, to merge or blend those two lines of cases. In our view, they're all consistent. There may be one or two stray cases where they forget to mention the caveat. But in the vast majority of these courts' pronouncements, the caveat is there. And it's one of the many ways in which Texas standing doctrine departs from federal standing rules. As Your Honor suggested, this is not unique. Many other ways in which Texas goes rules that go beyond federal standard.
Thank you, Mr. Mitchell.
Thank you, Your Honors.
Case is submitted. That concludes the arguments in the cases set for this morning, and the marshal will adjourn the court.
All rise. Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas now stands adjourned.